And we come to what hopefully is the final stage in the arbitration process, the award, the final decision on the case. Awards must be in writing. They cannot be issued orally at a hearing, and awards must be signed by at least a majority of all of the arbitrators. Dissents are allowed, or more properly, they are not prohibited by the rules. One of the three arbitrators, if it's a panel, may dissent. That dissent should be in writing and signed by the dissenting arbitrator. It is rare that you see dissents in arbitration, though, even in party-appointed cases. Just a note on signatures, the award may be signed in counterpart, which means each arbitrator may sign on a different page and the entire document collated. That would still constitute a valid award. The award must include, pursuant to AAA rules, an award of arbitration fees and expenses. These are the administrative costs, as well as the arbitrator's compensation and any expenses the arbitrator incurs. This can be a very important part of the award. Many years ago, arbitrators tended to just split the total of these two categories of expenses in half. And that often wasn't fair. Parties paid different filing fees and other administrative fees based on the size of their claims, and sometimes it is a particular party's behavior that may increase the arbitrator's compensation. So training of arbitrators, certainly for the last 10 years, has driven home this point that you don't want a party to walk away saying, I won on the merits, but I lost on the fees. So the arbitrators are provided with totals for the administrative fees and costs. They should be aware of their own compensation and take that into account at the end of a case. Note that some arbitration agreements do put somewhat of a limit on the arbitrator's authority with this particular aspect of the award. And what I have seen with a little frequency in construction, more frequency in some other industries, is a statement in the arbitration agreement which says the arbitrator must award the administrative fees and expenses and compensation to the prevailing party. But that clause often stops short of defining what the prevailing party is. In one interpretation, it could be someone who prevails 100% on all his claims, or it could be someone who receives 51% or more of his claims. So that would be something that would be good to be discussed at the preliminary hearing if there is such a limitation on the arbitrator's power in this particular area. And again, the award must be signed by the established due date or it's likely to be unenforceable. And the scope of the award must not exceed the arbitrator's authority. The arbitrator cannot issue an award that is binding on a non-party or issue an award based on claims that were not presented and proved in the case. Another selling point of arbitration is its flexible format and that the parties have some options in what form of award they get at the end of the case. The standard form is a disposition of all claims, and what it would look like is the case caption, a preamble, a recitation perhaps of the specifics of the claims, and then just a breakdown by claim or by issue. And in construction awards under the AAA rules, a breakdown is required. Some awards may be just as simple as X shall pay to Y or claim denied. Another form of award is what's called a reasoned award, and that is what it sounds like. It includes an opinion such as you would find attached with a court decision. If earlier in the case certain facts were in dispute and the determination of those facts was important to deciding the case, or similarly there was a question over the application of a certain law, then the parties may request an award with findings of fact or conclusions of law. Remember that form of award must be decided prior to the end of the case. The parties can agree in advance in their arbitration clause or the time of filing. If it is not resolved prior to the preliminary hearing, it must be resolved at that point and cannot be changed after the preliminary hearing without the consent of the arbitrator. And also note that if the parties have agreed on a specific form of an award, this is another area where the arbitrator's authority is limited. The arbitrator cannot overrule the parties on the specific form of award. Now, if an arbitrator or a panel of arbitrators issues an award and the parties voluntarily comply with it, that's the end of the case, and it should be the beauty of the arbitration process in that it is final and binding. But sometimes there are post-award issues. The first one, and the simplest, is a modification. There is a court procedure for modifying an award. The rules also provide for modification, but it is limited to certain errors. It is not a rehearing on the merits. The types of errors are clerical, typographical, technical, and computational. A computational error, then this is one of the reasons why breakdowns are in awards now, would simply be if the math didn't add up. But say a party had a claim for $75,000 and the arbitrator only awarded $50,000. The party cannot seek to have that issue clarified or reviewed or otherwise reheard by calling it a modification. It's a very simple process. A party seeking a modification submits, usually it's just in the form of a letter or a memo. The other side has a period of time to respond, and the arbitrator has choices. They can deny the request to modify, they can entertain it and make the modification, or if it's not the party bringing the error to the arbitrator's attention, if an arbitrator discovers in a timely manner that he or she has made a mistake that falls in one of these categories, then the arbitrator may, on his or her own initiative, issue a modification. Again, modifications are pretty simple and covered by, they do cover minor errors. If a disappointed party wants to try to overturn the award, that challenge process is called a motion to vacate or vacature of an award. This is a court proceeding. It is not the same thing as an appeal. It is not a request that the court review the merits again. There are limited grounds established by the Federal Arbitration Act or established by the state arbitration statute if it's a state act that's applicable. Listed here are those grounds enumerated in the Federal Arbitration Act. The first is that the award was procured by fraud. So if an arbitrator was bribed, that would be grounds for overturning an award through the vacature process. Second ground is evident partiality or corruption by an arbitrator. Most people would err on the side of thinking that partiality might be a way to overturn an award. It is an extremely high standard. The parties are going to have to show some direct connection. For instance, if an arbitrator never let the losing party speak, if the arbitrator proceeded with communications unilaterally with the other side, it would have to be extreme for there to be a showing of evident partiality that rises to the level of an award being vacated. The next reason for vacature would be arbitrator misconduct, such as refusal to postpone a hearing after good cause shown, which results in prejudice to the party, or if an arbitrator were to refuse to allow in certain evidence. But again, this is a very, very high bar. If a party has asked for 3 postponements and the arbitrator granted the first 3, an arbitrator is probably going to be well within his rights to say no to the 4th one. Or likewise, if a party has presented 3 or 4 fact witnesses that have said essentially the same thing, an arbitrator could deny that party the right to present more fact witnesses on the same subject and not be subject to reversal. And finally, if an arbitrator exceeds his or her powers or executed them so poorly that a final indefinite award was not made, and this would be, as we've mentioned earlier, if an arbitrator made an award that awarded money or required specific performance from a party who was not a party to the actual arbitration proceeding. So again, all of these are very high standards. It is rare that a case is actually overturned by a court. The standards above, as mentioned, are statutory grounds for moving to vacate an award. There are some other possible ways an award can be vacated. Over time, case law has developed and certain precedents have been established. One of those is called manifest disregard of law. This is more than just a mistake in the application of law. The party needs to prove that the arbitrator must have been extremely well aware of the law that is at issue and knowingly ignored it or refused to apply it in the decision-making process. So again, it is an extremely high bar, but it is a little more open than those grounds enumerated under the federal and state statutes. Whether or not a court recognizes manifest disregard as a basis for vacating an award varies greatly by jurisdiction. So it's important, if a party is considering moving to vacate an award, that he does his research thoroughly and understands whether or not this is even an option in his jurisdiction. There may be some other non-statutory grounds, but again, they vary by jurisdiction, and the primary ways to vacate an award are those enumerated by the FAA. And again, vacature of awards is very rare. Now, if the parties or the prevailing party wants to proceed and have the award confirmed by a court, it is a very simple process. The party files a motion. There does not need to be a pre-existing litigation. And the confirmation process basically just converts the arbitrator's award to a judgment, which means that the prevailing party in the arbitration has the rights and remedies available as if they had gone through litigation. There are some time standards established on the procedures for vacature, and so it makes sense that the parties wait till those time standards have passed. They differ whether it's under the federal statute or the state statute. If a party files a motion to confirm before those motions to vacate periods have expired, the court is not going to confirm an award until such time as that opportunity for the losing party to file a motion. But a motion to confirm is filed. There is no opposition to it. Again, there is no rehearing on the merits. The courts recognize the validity of arbitration and will confirm the award, and the party who won has more ability to collect on that award. So again, a motion to vacate is not the same as an appeal. For many, many years, there was really no such thing as an appeal of an arbitration. However, in recent years, all three of the providers have developed appellate procedures. One of the reasons parties did not use arbitration was because it lacked an appeal process. This is still a controversial issue. There are many, many people who think that arbitration should be final and binding with only those limited grounds to move to vacate an award. But there are also many other people who feel that an appellate process is necessary. So again, this shows a benefit of having these national ADR providers. They do the research, they listen to the clients, and they develop applicable procedures. The appellate procedures of the AAA are available on their website. Again, it's important to note that this is not a rehearing on the merits, and the arbitrator who hears the appeal is not going to be the same arbitrator who heard the merits of the case. The scope of review is slightly more expansive than the statutory grounds. The parties seeking an appellate remedy may request that the matter be reviewed for errors of law that are prejudicial or determinations of facts that were clearly erroneous. There are time standards, and this process can only be used if all of the parties agree, and there are administrative fees and costs, so it is worth a look at the appellate procedures. Finally, before we leave awards, we want to talk about a concept called splitting the baby. This is a perception widely held, although it is a myth, that arbitrators tend to just divide claims equally. There's a great deal of research that disproves this theory. So if you hear the term splitting the baby, know that it is someone who is not up on the field of arbitration. Finally, the last two slides, as indicated earlier, links to the Federal Arbitration Act and the Massachusetts Uniform Arbitration Act, and then to the arbitrator codes, that of the AAA and those of JAMS.